Good afternoon, ladies and gentlemen. I'm Robert George, Director of the James Madison Program in American Ideals and Institutions and McCormick Professor of Jurisprudence here at Princeton University. It's my pleasure to welcome all of you to the 2025 Herbert W. Vaughan Lecture on America's Founding Principles. The James Madison Program is dedicated to exploring enduring questions of American constitutional law and political thought. If you'd like to learn more about our program and everything we do, please visit our website at JMP, James Madison Program, jmp.princeton.edu. You can also follow us on Twitter, X, and our handle there is simply @Madison Program. On our website, you can sign up, and I hope you will, to receive our newsletter. And you can subscribe to our wonderful podcast, Madison's Notes. You can learn more about upcoming events, both virtual and more often these days, of course, thank goodness, in person. And it is my very great pleasure to welcome you and to welcome our distinguished visitor. Now, Herbert W. Vaughan was my mentor at the law firm of Hale and Dorr in Boston, where I briefly practiced law before going on to doctoral studies. Mr. Vaughan and I remained close friends, and he became a generous supporter of the James Madison Program and a founding member of the Madison Program's Advisory Council, on which he served until his death. In establishing the Vaughan Lecture and a parallel Vaughan Lecture at Harvard Law School, Wiley, as we knew him, Herbert Wiley Vaughan, Herbert W. Vaughan, Wiley asked that the following statement be read, and so I'll read it here today. I, Herbert W. Vaughan, have endowed this lecture at Princeton University to promote and advance understanding of the founding principles and core doctrines of American constitutionalism. What Alexander Hamilton said to the Americans of his day remains true for Americans of every generation. And here Mr. Vaughan quotes the famous passages from the very first Federalist paper. It seems to have been reserved to the people of this country by their conduct and example to decide the important question whether societies of men are really capable or not of establishing good government from reflection and choice, or whether they are forever destined for their political constitutions on accident and force. And then in his own voice, Mr. Vaughan concludes, in my judgment, the Constitution of the United States is the greatest practical achievement of political science. It is a testament to the extraordinary gifts of creativity, prudence, and high-mindedness possessed by the founders of our nation. May you, and here he's speaking to all of us, may you be guided and inspired by their genius as you meet the challenges of the present day. Well, what a delight, and I know how pleased Wiley Vaughan would be to welcome back to Princeton my beloved former superstar student, Professor Joel Alicea. Professor Alicea is the Robert Bellarmine Professor of Law at the Catholic University of America's Columbus School of Law. He's also the director there of the Law School's Center for the Constitution and the Catholic Intellectual Tradition. Professor Alicea served as a law clerk, first for Judge Diarmuid O'Scanlan of the U.S. Court of Appeals for the Ninth Circuit, and then at the Supreme Court of the United States for Justice Samuel Alito. Professor Alicea's scholarship focuses on constitutional theory, and his work has appeared in such eminent publications as the Yale Law Journal, the University of Pennsylvania Law Review, the Virginia Law Review, which is the law review of the University of Virginia and its distinguished law school, and the Notre Dame Law Review. Professor Alicea, of course, earned his undergraduate degree with every conceivable honor and recognition here at Princeton University, and then he went on to Harvard Law School. His lecture for us today is entitled Bruen, referring to the famous Second Amendment case, the Bruen case, and the founding era conception of rights. Please join me in welcoming back to Princeton in the Madison Program, Professor Joel Alicea.
Well, thank you, Robbie, and thanks to all of you for coming today to this lecture at the James Madison Program. It is such an inversion for me to be here speaking to you all as the lecturer for the Vaughan program and for the Madison program. I, of course, was an undergraduate fellow myself and I'm sure I attended a Vaughan lecture at some point and attended many JMP events during my time here 15 years ago. And so it's really extraordinary for me to now be at the front of the room delivering this. In 2022, the Supreme Court issued its decision in New York State Rifle and Pistol Association versus Bruen, holding that the Second Amendment protects an individual right to carry arms outside the home. That holding, however, was not the most significant aspect of the decision. The most significant aspect was the methodology that the court adopted for adjudicating claims under the Second Amendment. Bruen set forth a two-step test for adjudicating the constitutionality of firearms regulations, with the first step focusing on the text of the Second Amendment and the second focusing on our historical tradition of firearms regulation. In doing so, the court criticized and replaced the test that had been adopted by all the courts of appeals prior to Bruen, a test based on the tiers of scrutiny that have become a dominant feature of rights jurisprudence since the 1960s. By explicitly rejecting the tiers of scrutiny and opting for a text and history test under the Second Amendment, the court signaled a potential revolution in its approach to adjudicating constitutional rights. The court argued that its text and history methodology was more legitimate than judicial interest balancing tests like the tiers of scrutiny because it faithfully captured, quote, the balance struck by the founding generation. Bruen therefore tied the legitimacy of its methodology to the methodology's ability to accurately reflect the way the Second Amendment was understood at the founding. Yet it's fair to say that Bruen assumes rather than proves the historical accuracy of its conception of constitutional rights. Such an assumption cannot be made in light of recent scholarship by Judd Campbell, Jonathan Gannap, and Jamal Green, whom I will refer to here as the rights revisionists. I hasten to make clear that I do not intend that label to be pejorative or dismissive. All three authors have described their own work as challenging an understanding of rights that has been dominant within American legal culture since at least the middle of the 20th century. So rights revisionist seems just like a descriptively accurate label. These three scholars have argued that constitutional rights at the founding were generally understood as grounded in the natural rights tradition. The textual declaration of such rights in the Constitution often pointed the reader to a pre-existing body of law and political theory outside of the text, such that the text was a, quote, mere placeholder, in Campbell's phrase, for the content of the right. And because natural rights were subject to government regulation for the common good, they were not generally seen as judicially enforceable trumps on government action. Rather, representative institutions like legislatures had significant authority to determine the limits of natural rights, despite their enumeration in the Bill of Rights. Proceeding from these premises, Campbell and Gannap have argued that Bruen's methodology overstates the relevance of constitutional text in recovering the original meaning of natural rights declared in the Bill of Rights. They also contend that Bruen erroneously assumes that constitutional rights like the Second Amendment operate as judicially enforceable trumps on government action. But the critics of Bruen's methodology are mistaken. By describing the text as a mere placeholder, they overlook Campbell's own descriptions of how the founders understood the role of the text. By accusing Bruen of undercutting democratic governance, they misunderstand Bruen's methodology. And by disparaging Bruen's historical analysis because it assumes that rights generally operated as trumps on government action, they overstate the extent to which constitutional rights were seen as regulable by legislatures at the founding. On each of these points, Bruen's methodology is not only grounded in the founding era conception of rights, it is consistent with the rights revisionist's own account of rights at the founding. There need be no significant conflict between Bruen's methodology and rights revisionism. In making this argument, I will proceed in three parts. First, I will provide an overview of Bruen's methodology. Second, I will set forth the main features of the rights revisionist account of rights at the founding and lay out Campbell and Gannap's critiques of Bruen's methodology. Finally, I will argue that the rights revisionist conception of rights is generally compatible with Bruen's methodology. Campbell and Gannap claim to the contrary, and that those claims to the contrary are based on either a misunderstanding of Bruen's methodology or assertions that are inconsistent with the relevant history, often including their own account of that history. This is not only a debate about intellectual history, though. even though that would be a very worthwhile conversation to have. At issue is the future of how the court adjudicates constitutional rights. Bruen has put forward a new methodology for doing so, one that it presents as superior to the tiers of scrutiny. But because Bruen ties the legitimacy of its methodology to the founding era conception of rights, if its methodology is ahistorical, Bruen's coherence and legitimacy would be undermined, and Bruen's nascent revolution might falter. The stakes of the historical critique of Bruen's conception of rights are therefore quite high, and with some of the nation's leading scholars offering such critiques, the need for a defense of Bruen's conception of rights is pressing, and I offer that defense here today. I will begin with an overview of Bruen's methodology. In a forthcoming article in the University of Pennsylvania Law Review called Bruen Was Right, I provide a comprehensive exposition and defense of Bruen's methodology from conceptual and doctrinal critiques. So here I will only give a brief summary of the methodology and assume the correctness of my interpretation of Bruen, even though I concede that it's controversial. I will move through these contested conceptual issues quickly because my focus in this lecture is on the historical soundness of Bruen's methodology. Bruen adopts a two-step test for adjudicating Second Amendment claims, as I said earlier. Step one is a textual analysis that focuses on the original linguistic meaning of the Second Amendment, what the words meant at the time they were ratified. The court already performed almost all the textual analysis for step one in District of Columbia versus Heller in 2008, a foundational Second Amendment case, which expounded the original linguistic meaning of the Second Amendment on its way to holding that the amendment protects an individual right to keep and bear arms for self-defense. The Second Amendment's operative clause contains three textual elements relevant to the step one inquiry: the people, keep and bear, and arms. The amendment focuses on who the rights claimant is, the conduct in which the rights claimant has engaged or wishes to engage, and the object the rights claimant employed or wishes to employ as part of that conduct. The question at step one is whether the rights claimant has satisfied all three textual elements under the plain text of the Second Amendment. So, for example, in Bruen, because the rights claimants in that case were part of the people, because the handguns that they wished to carry were arms, and because carrying those arms outside the home is bearing arms, they fell within the plain meaning of the Second Amendment. Under Bruen, when a claim or defense falls within the plain meaning of the Second Amendment, the Constitution presumptively protects that conduct, and the burden shifts to the government to rebut the presumption. Put another way, step one gives rise to, quote, an initial conclusion, in Bruen's words, that must be confirmed by historical analysis at step two. Assuming we get past step one's textual analysis, step two is a historical analysis. The question at step two is whether the government's regulation, quote, is consistent with the nation's historical tradition of firearm regulation, unquote. Bruen, like Heller, presupposes that the Second Amendment, quote, codified a pre-existing right and was not intended to lay down a novel principle, unquote. It therefore recognizes that historical tradition, not text, determines the constitutionality of a firearms regulation once the rights claimant has satisfied step one, though the historical analysis cannot contradict the text. Because Bruen proceeds from originalist premises, the historical analysis at step two focuses on the years immediately surrounding ratification, though the court has yet to clarify whether the relevant ratification year is 1791, when the Second Amendment was ratified, or 1868, when the 14th Amendment was ratified due to a doctrine called incorporation. To carry its evidentiary burden, the government need only show that historical tradition supports its regulation. It need not show, in Bruen's words, that the modern regulation is a historical twin of the prior statute. Traditions are reflected in practices, but they are not reducible to practices. A tradition describes some principle or set of principles that explain and justify and unify the practices. But it is the principles, not the practices, that constitute the tradition. That is why the court in Bruen and its most recent decision, United States versus Rahimi, described the step two inquiry as, quote, applying constitutional principles to novel modern conditions, unquote, as looking for, quote, modern principles that underpin our regulatory tradition, unquote. The government can only succeed at step two by demonstrating that the ends and means of its modern regulation are similar to the ends and means reflected in the principles that constitute our historical tradition of firearms regulation. In Rahimi, for instance, the court concluded that our regulatory tradition of surety and affray laws reflected the same end, preventing individuals who threaten physical harm to others from misusing firearms, and the same means, temporary disarmament, as 18 U.S.C. 922 G8C. It sustained the constitutionality of that federal statute on the basis of this comparison between historical means and ends and the modern regulations means and ends. In this way, step 2 attempts to, quote, apply faithfully the balance of interest struck by the founding generation to modern circumstances, unquote. In short, Bruen's two-step test is designed to recover the original contours of the right to keep and bear arms. It does so by giving due importance to the text of the Second Amendment, to draw an initial conclusion, in Bruen's words, about the modern regulation's constitutionality. It then turns to history to flesh out the substance of the right and determine definitively whether the right has been violated. So that's Bruen's methodology. With that understanding, let's turn to the account of rights offered by the rights revisionists. Now, I don't contend that Campbell, Gnap, and Green agree on all aspects of the account that I'm about to offer here, or sketch out here. What matters for my purposes is that where Green and Gnap give an account of rights, their accounts are consistent with Campbell's. And because Campbell's is the most detailed account of rights among the three authors, I will rely mostly on Campbell's account in describing rights revisionism. The revisionist account is rooted in a social contractarian understanding of political authority. On this view, we begin by imagining human beings in a state of nature prior to any government. In a state of nature, all human beings enjoy natural rights, which are, in Campbell's description, capacities one could exercise without a government, such as the freedom to think, speak, and enjoy the fruits of one's labor. While no political authority exists to regulate natural rights in a state of nature, such rights are nonetheless subject to the limitations of the natural law. But we often have difficulty identifying the requirements of the natural law. And even when we do, it leaves innumerable matters of conduct underspecified, which makes social coordination and furtherance of the common good impossible. The natural law does not, for example, tell us which side of the road to drive on to avoid injuring others, to use a common example, even though avoiding injuring others is generally a requirement of the natural law. These features of natural law create the need for an authority to both identify and make more determinate the requirements of the natural law. Accordingly, a group of people unanimously agreed to leave the state of nature and enter into a social contract, under which the group has political authority to regulate the actions of its members in furtherance of the common good. This political society, in turn, delegates some portion of its powers to the government. But not just any kind of government. The people had to maintain control over their natural rights in the founders' view, which meant that only representative government was consistent with social contract theory. A small class of natural rights were inalienable, in the sense that they were outside of political authority's control, and they were seen as trumps on government action to the extent that they were determinate. The right to self-defense was one such right. But most natural rights were retained natural rights, subject to broad regulation in furtherance of the common good. The people regulated their retained natural rights through various representative institutions, including the common law, legislatures, and juries. The common law was viewed as a representative institution at the time because, in contrast with today's kind of very legal realist way of thinking about the common law was thought to be merely a reflection of the customs and practices of the people. So we have inalienable rights on the one hand, which were trumps on government action, and retained natural rights on the other, which were generally not trumps and were regulable for the common good. But there was also a third category of rights, fundamental positive law rights. Campbell describes these rights as, quote, specifying things that the government had to do or could not do, unquote. They were, in other words, specifications and regulations of natural rights through common law or written positive law. Common law rights, such as freedom of the press and the right to a trial by jury, as well as written positive law rights not based in the common law, like the right against bills of attainder, are examples of fundamental positive law rights. As Federal Farmer observed, in the case of common law rights that had achieved this status, it was because they were, quote, so strengthened by long usage as not to be repealable by the ordinary legislature, unquote. Fundamental positive law rights were thus judicially enforceable to the extent that their contours were clear, and they functioned as trumps on government power. Because fundamental positive law rights were concretizations of natural rights, one could imagine a smaller circle of fundamental positive law rights nested within a larger circle of natural rights. And the same is true of inalienable rights, nested within the larger circle of natural rights. There was thus always space within the domain of natural rights that did not function as judicially enforceable limits on government authority. This area consisted of retained natural rights that were safeguarded through representative institutions, as I described earlier. So these three different types of rights, inalienable, retained, fundamental positive law, had implications for the enumeration of rights in texts like the Bill of Rights. So keep in mind those three types of rights as we now turn to the different ways in which constitutional text might incorporate these rights through enumeration. Sometimes a text merely declared the existence of a natural right, such as the free exercise of religion. In such instances, the text did not specify the right's contours. The right was not a textual object, in Campbell's words. Rather, Campbell says that the text was a mere placeholder, pointing the reader outside of the text, requiring the reader to, quote, identify the content of the law by referring to pre-existing principles, unquote. In other instances, the text served a specificatory function. In those cases, the text, quote, created positive fundamental law by determining rights, in Campbell's words. That is, the text made more determinate the contours of a natural right or created positive law means of safeguarding a natural right, as in the case of trial by jury, habeas corpus, and freedom of the press. In Campbell's words, where lawmakers had textually specified the content of the law, a, quote, text-bound interpretive approach made sense since the content of the right depended on the verbal formula used to specify the right. Now, one might think, based on what I've said up till now, that declaratory provisions correspond to retained natural rights, while specificatory provisions correspond to fundamental positive law rights. But unfortunately, that would be an oversimplification. Things are more complicated than that. Sometimes a constitutional text, despite declaring a natural right, pointed readers to principles outside the text that were inalienable or fundamental positive law rights. In other words, to say that a provision is declaratory simply means that one has to go outside the text to recover its content, not that the provision necessarily embodies a retained natural right rather than a fundamental positive law right or an inalienable right, or components of each of those could be mixed together in a declaratory provision. For example, Campbell argues that the free speech clause is a declaratory provision that refers to a natural right. But part of the right to free speech included the inalienable natural right to make, quote, well-intentioned statements of one's views, in Campbell's words, which entailed more determinate legal protections against government power, protections that were themselves trumps on government authority. The free press clause, though part of a larger natural right of free expression, quote, often referred specifically to the rule against press licensing or prior restraints, a rule that had become settled and therefore a fundamental positive law rule that operated as a trump on government action. Thus, identifying the scope of judicially enforceable legislature trumping constitutional rights was complex. One had to figure out whether a constitutional provision was declaratory or specificatory, and even once one had done that, you could not assume that a declaratory provision gave the legislature free rein to regulate the common good, since some declaratory provisions referred to inalienable or fundamental positive law rights that served as trumps on government action. So a careful parsing of pre-existing law was necessary to make such distinctions. Now, this account of rights that I just laid out differs in several ways from the Supreme Court's rights jurisprudence since at least the 1960s. I'll just highlight three ways here. First, rights revisionism is firmly rooted in natural law and natural rights conceptions of rights. Under this view, some rights, though declared in written law, pre-exist political authority and are not created by legal text. And natural rights are part of our fundamental law, even if they had not been enumerated in the Constitution. By contrast, modern rights jurisprudence is heavily influenced by positivist notions of law and of rights, in which constitutional rights in particular owe their existence to their enumeration in the Constitution and would not exist otherwise. Second, and related to the first point, the rights revisionist view places significantly less weight on the wording of textual declarations of natural rights. The text is a mere placeholder for principles that lie outside the text, so it makes little sense to parse the text of the Second Amendment in the same way one might sensibly parse the words of a purely positive law provision like the Commerce Clause. Third, this account of rights understands declaratory rights provisions like the Free Speech Clause to be, in Campbell's words, quote, expansive in scope, applying to all forms of expression, but weak in their legal effect, unquote. Whereas modern rights jurisprudence generally conceives of rights as legal trumps on government action, rights revisionism sees rights as trumps in only a limited domain, with the remaining space consisting of retained natural rights left open to reasonable government regulation for the common good. Rights revisionism is therefore skeptical of claims that the content of rights is fixed, whether through original meaning or through judicial decree, rather than subject to continuous elaboration and modification through representative institutions over time. As Green has argued, quote, the provisions of the Bill of Rights are best viewed as protecting self-governance, not individual liberty from the majority, end quote. Now, some of these distinctive features of rights revisionism have led Campbell and Gannap to criticize Bruen's methodology as inconsistent with the founding era conception of rights in at least two ways, which map onto the two steps of Bruen's analysis. So let's turn now to Campbell and Gannap's criticisms of Bruen's methodology. First, Campbell and Gannap argue that Bruen's step one places too much weight on textual analysis, given that the Second Amendment is declaratory of a natural right. Gannap faults step one for, quote, closely analyzing the precise formula of the text, unquote, which he regards as contrary to the natural rights assumptions of the founding. Campbell calls step one the most problematic part of Bruen's analysis because it, quote, derives the presumptive boundaries of the right through close textual analysis based on the meaning of the words at a particular moment in time, thus treating the Bill of Rights as a specificatory instrument, unquote. Second, Gannap contends that Bruen's step two presupposes that the Second Amendment is, quote, fully determinable and non-regulable, functioning as a trump on government action. But in fact, the Second Amendment was meant to, in his words, ensure legitimate and robust self-governance through representative institutions. Campbell likewise criticizes step two for assuming that the right to keep and bear arms was, quote, fully determined from the get-go, barring subsequent determinations, unquote. In Campbell's view, the net result, is a quote, is a jumbled interpreted method that undercuts democratic authority in countless ways the founders never intended. These criticisms of Bruen are mistaken. They rest on a combination of overstatement, a misunderstanding of Bruen's methodology and premises, and in some instances, a misreading of the historical record. Let's begin with the criticisms of step one, and with a few points that the revisionist account gets right. The revisionist contention that the founders were steeped in the natural law and natural rights traditions and would not have conceived of rights in positivist terms is clearly correct. Campbell is spot on in saying that the founders would not have regarded the natural rights in the Bill of Rights as textual objects. Rather, quote, when the text merely referred to a pre-existing right, it was second nature to identify the content of the law by referring to pre-existing principles, end quote. That's Campbell's quote. Completely agree with that. This understanding of the relationship between natural rights and constitutional text, however, is fully consistent with Bruen. Like Heller, Bruen starts from the premise that the Second Amendment, quote, was not intended to lay down a novel principle. Bruen affirms that it has always been widely understood that the Second Amendment codified a pre-existing right, one rooted in the natural right of resistance and self-preservation. This is why step one's textual analysis only creates a presumption, Bruen's word, that the right has been infringed. This presumption is just that, an initial conclusion, as Bruen states. It must be confirmed by the historical record. Thus, as Rahimi states, the, quote, delineation of the contours of the right, unquote, is performed at step two, not at step one. And in determining the contours of the right, the court looks to, quote, the pre-existing principles underlying the Second Amendment, unquote. Nonetheless, Gannap criticizes step one for closely analyzing the precise formula of the text, as I said earlier. But from the premise that the text is merely declaratory of a pre-existing right, it does not follow that the precise wording of the text should play no significant role in understanding the scope of that right. The First Congress paid careful attention to the wording of the Bill of Rights in an effort to capture, as much as the spare wording of its provisions allowed, the understanding of the rights that pre-existed their enumeration. It therefore makes sense for us to pay careful attention to the words they chose. And there's ample historical evidence to support this conclusion. During the congressional debates over the Bill of Rights, Madison repeatedly urged his colleagues to, quote, confine themselves to an enumeration of simple acknowledged principles, unquote. This meant that the wording of the amendments had to reflect such simple acknowledged principles. Indeed, in introducing his proposed amendments, Madison criticized the wording of some state declarations of rights for failing to accurately reflect the pre-existing understanding of certain rights. Given the goal of producing amendments whose text aligned with well-accepted pre-existing scope of declared rights, it's not surprising that throughout the debates over the Bill of Rights, members of the House objected to the wording of various proposed amendments for failing to achieve that goal. One such objection, for example, occurred during the debate over the Double Jeopardy Clause, when Egbert Benson resisted the wording of the draft clause as, quote, contrary to the rights heretofore established, unquote. Samuel Livermore disagreed, arguing that the wording was, quote, declaratory of the law as it now stood, unquote, such that striking out the words that Benson wanted to omit would, quote, seem as if they meant to change the law by implication, unquote. Livermore instead sought to have the text reflect, quote, the usages of law and practice among us, unquote. Similar concerns about the extent to which the text captured settled principles were expressed about the self-incrimination clause, the cruel and unusual punishment clause, and what would eventually become the establishment and free exercise clauses. Indeed, the wording of the proposed amendments underwent, quote, considerable debate and alteration, in the words of Congressman William Lofton Smith. Perhaps one or more of the provisions that I just used as an example might be considered specificatory. And since rights revisionists see such provisions as textual objects, those examples would not seem to be as probative of the relevance of text for declaratory amendments. But as Campbell has observed, quote, even when debating declaratory proposals, congressmen remained attentive to the text, unquote. In addition to the Double Jeopardy Clause example I just described, which Campbell notes was intended to be a declaratory restatement of the common law rule, Campbell gives the example of the debate over the Fourth Amendment. There, Elbridge Gerry objected to the wording of the draft Fourth Amendment and proposed a change that was adopted, apparently, in Campbell's own view, to ensure that the provision reflected pre-existing principles. Benson and Livermore, in turn, proposed further changes to the Fourth Amendment, which Benson described as a declaratory provision, but those were rejected. A similar punctiliousness about wording is seen in the discussion of a proposed declaratory amendment relating to speech, press, conscience, and trial by jury rights that was intended to originally bind the states, and in discussions of the prefatory clause of the Second Amendment. In short, as Campbell has said, because the goal was merely to declare uncontroversial principles, quote, members of the First Congress expressed agnosticism about the amendments alongside profound concerns about their wording, unquote. Thus, Campbell concludes, quote, even with respect to declaratory provisions, the text and drafting history are probative evidence of how the right was understood, end quote. There is thus no historical basis for criticizing Bruen's attention to the text of the Second Amendment. Now, unlike Knapp, Campbell does not criticize Bruen for paying attention to the text. How could he, given what he just said? Rather, he argues that Bruen places too much weight on the text because it, quote, derives the presumptive boundaries of the right through close textual analysis based on the meaning of the words at a particular moment in time, unquote. Essentially, Campbell criticizes Bruen for shifting the burden to the government at step 2 based on the textual analysis at step 1, since the text was supposed to be, in his words, a mere placeholder for the principles outside of the text. But if, as Campbell says, the First Congress demonstrated profound concern, his words, about the wording of declaratory provisions like the Second Amendment, and if the reason the First Amendment paid such close attention to the text was, in Livermore's words, to ensure that they were, quote, declaring the law as it then stood, unquote, it makes sense to treat a violation of the text as prima facie evidence of a violation of the underlying right. True, as Madison conceded, the text could only describe the right as well as the nature of the language would admit, in his words. We know that there were, in fact, aspects of the right that were not fully captured by the text, such as the regulatory tradition recognized in Rahimi that I described earlier. But that's why Bruen only establishes a presumption based on Step 1's textual analysis, a presumption that can be rebutted after Step 2's historical analysis, which recovers the more precise scope of the right. But Bruen's notion that the text can provide prima facie evidence of a rights violation is well grounded in the debates of the First Congress. Indeed, we see a heavy emphasis on the text of a declaratory rights provision in the first major constitutional rights dispute of the early republic, the fight over the Sedition Act. Critics of the Sedition Act often claim that the plain text of the First Amendment was sufficient to demonstrate the act's unconstitutionality, not just prima facie evidence of it. Congressman Nathaniel Macon, for example, responded to a defense of the act by Massachusetts Harrison Gray Otis by stating, quote, "When the words of the Constitution were so express, it seems impossible they could be understood as the gentleman from Massachusetts had represented them," unquote. It's a striking fact that only 7 years after ratification of the Bill of Rights, in the first major dispute over constitutional rights, one side invoked the text of a declaratory provision as strong evidence of unconstitutionality. These early interpreters apparently saw no problem with placing such weight on the text, nor should we find Bruen's more modest reliance on the text objectionable. A similar dynamic is present at Step 2. The rights revisionists assail Bruen on grounds that either misunderstands Bruen's methodology or that, on the revisionist's own historical account, ought not be objectionable. Now, as a reminder, Campbell criticizes Step 2 for treating the content of rights as, quote, fully determined from the get-go, barring subsequent determinations, unquote, and Gannap says something very similar. In evaluating this critique, it's important to begin by keeping in mind Campbell's distinction between retained natural rights that are regulable by the government for the common good and inalienable rights or fundamental positive law rights that serve as trumps on government action. And we need to further distinguish these three categories of rights from enumerated constitutional rights, which may or may not map onto one or more of the three categories of rights. As I mentioned earlier, Campbell acknowledges that declaratory constitutional provisions can contain a mixture of retained natural rights on the one hand and inalienable or fundamental positive law rights on the other, such that some aspects of declaratory constitutional rights are subject to regulation for the common good, while others are not. In his view, that is true of the First Amendment, which he claims, quote, recognized any customary legal principles that protected speech and press, while also recognizing that apart from these rules, Congress was otherwise free to limit expression in pursuit of the common good, unquote. This is consistent in application, this view that Campbell just summarized, is consistent in application with how Bruen understands the Second Amendment. Bruen uses text and history to identify the fixed legal content of the right, while otherwise allowing legislatures to regulate for the common good. Now, to be clear, I'm not arguing that Bruen consciously adopts the understanding and categorization of rights Campbell articulates, the labels that he uses. Rather, my point is that when Bruen simultaneously asserts that its methodology does not impose a, quote, regulatory straitjacket, and that, quote, the Second Amendment is the very product of an interest balancing by the people, unquote, Bruen is saying nothing that, in application, necessarily contradicts Campbell's notion that some conduct involving firearms remains subject to regulation, while other conduct does not. Campbell calls the domain subject to regulation retained natural rights, whereas Bruen seems to conceive of that same domain as not part of the right. Campbell calls the domain of fixed legal content fundamental positive law rights, whereas Bruen seems to conceive of that same domain as simply the right. But both ways of thinking about rights agree that there is some conduct involving firearms subject to regulation and other conduct that is not subject to regulation. They are simply disagreeing about how to describe the boundary between the two domains. In fact, insofar as the Second Amendment refers exclusively to more determinate customary rules without directly recognizing retention of the broader but shallower natural law right, then there would be no tension at all between Bruen's description of the Second Amendment and Campbell's. Bruen and Campbell would agree in that situation that the domain of fixed legal content simply was the right declared by the Second Amendment, with no retained natural right recognized by the text. Importantly, Campbell notes the possibility of this very interpretation in the First Amendment context and points out that, quote, Federalists in the 1790s often interpreted the First Amendment in precisely this way, unquote. That is to say, they interpreted the First Amendment as only recognizing the fundamental positive law component of the right. And therefore, the constitutional right was coterminous with legislative trumping fundamental positive law rights. The same could, in principle, be true of the Second Amendment. But the larger point here is that even if the Second Amendment does recognize a domain of retained natural right, one could easily redescribe Bruen's methodology to accord with Campbell's conceptual categories. Under this approach, within the fixed boundaries set by the Second Amendment after Step 2, legislatures make determinations about the retained natural rights component of the constitutional right to keep and bear arms. For example, as Bruen noted, there's a historical tradition allowing legislatures to determine whether to prohibit the possession of arms in sensitive places defined by certain criteria. Because prohibiting possession of arms in such places does not offend the fixed component of the Second Amendment, it's entirely within the legislature's power to decide whether to prohibit such arms and in which locations, again, subject to the historical principles and criteria. Thus, one could theorize Bruen's methodology as taking some aspects of the declared right to keep and bear arms as fixed, while treating other aspects as adjustable by legislatures for the common good, just as Campbell does in the First Amendment context. Since Campbell acknowledges that some component of declaratory constitutional rights can be fixed, his objection to Bruen's methodology is better formulated as an objection to how much of the constitutional right to keep and bear arms Bruen regards as fixed. Campbell seems to think that because the rights claimant's success at Step 1 creates a presumption against government regulation, because Step 1's presumption is based on the text of the amendment, and because the text of the amendment is broad and unqualified, Bruen's methodology is likely to result in a constitutional right with a broad domain of fixed, non-regulable content, which Campbell seems to believe is an inaccurate understanding of how much of the Second Amendment's content was fixed. That's why he claims that Bruen's methodology, quote, undercuts democratic authority in countless ways that the founders never intended, unquote. But it's fair to ask how Campbell can be so confident that the Second Amendment does not enshrine a constitutional right with expansive fixed content. During debates over the ratification of the original Constitution, during debates over the Bill of Rights in the First Congress, and during debates over the Sedition Act, there were many statements indicating a conception of the Bill of Rights as primarily, if not exclusively, composed of fixed legal content that trumped legislative authority. These statements often described enumerated rights as exceptions to, or the opposite of, government power. And as Campbell has acknowledged, descriptions of exceptions to legislative power at the founding were indicative of rights that served as trumps. I do not claim that this is the only view found in the debates at the founding. Nonetheless, in light of the many statements reflecting something like a rights as trump view, there is significant evidence that it was a common and perhaps even dominant conception of constitutional rights at the founding. For example, at the ratification debate in Virginia, James Monroe urged the need for a Bill of Rights to, quote, expressly secure or accept rights from the federal government's power. The language of exception, as I just noted, typically indicated a rights as trumps view. During the First Congress, when introducing the amendments that would become the Bill of Rights, Madison contrasted the status of rights under the British Constitution, which he called, quote, unguarded, with the Bill of Rights he was proposing, which would, quote, limit and qualify the powers of government by accepting out of the grant of power those cases in which the government ought not to act, or to act only in a particular mode, unquote. Notably, Madison made his comments after identifying inalienable natural rights, retained natural rights, and fundamental positive law rights, as Campbell does, while maintaining that, quote, whatever may be the form of a Bill of Rights, its purpose was to lay down, quote, exceptions to government power. And to drive the point home, Madison repeatedly characterized Bills of Rights as operating, quote, against the majority and in favor of the minority, unquote, which, by the way, is just directly contrary to Green's description of how the founders understood the Bill of Rights. Famously, Madison followed these statements up by pointing out that once a Bill of Rights was added to the Constitution, this is a more extended quote, independent tribunals of justice will consider themselves in a peculiar manner the guardians of those rights. They will be an impenetrable bulwark against every assumption of power in the legislative or executive. they will be naturally led to resist every encroachment upon rights expressly stipulated for in the Constitution by the Declaration of Rights. Now, as Campbell has noted, natural rights were generally not judicially enforceable unless some component of them had become sufficiently determinate and established in law to become fundamental positive law rights. So Madison's description of the judiciary as an impenetrable bulwark against legislative power based on rights expressly stipulated by the Declaration of Rights, without a similar description of the legislature's ongoing power to regulate such rights, suggests a relatively expansive view of the fixed legal content of those rights. Such a rights as Trump's view would be consistent with Madison's later view in the Virginia Resolutions of 1798, and with Thomas Jefferson's views expressed in a letter to Madison in March 1789. It would be the same view about the inverse relationship between rights and powers captured in Madison's letter to George Washington in December 1789, where Madison said, quote, "If a line can be drawn between the powers granted and the rights retained, it would seem to be the same thing, whether the latter be secured by declaring that they shall not be abridged, or that the former shall not be extended," unquote. Campbell is, of course, aware of all of these statements, and he devotes considerable time to offering an alternative interpretation of Madison's remarks about the Bill of Rights to support his view that Madison did not, in fact, hold a rights as Trump's understanding of the Bill of Rights. But respectfully, I find Campbell's interpretation rather strained and difficult to square with what Madison says. It's worth noting in this regard that by Campbell's own account, the vast majority of scholars have interpreted Madison's remarks as I do, which I think is the more straightforward interpretation of what Madison is saying. The same theme of rights as Trump's is found on both sides of the Sedition Act debate. Campbell points out that, quote, Federalists in the late 1790s often interpreted the First Amendment as referring exclusively to more determinate customary rules without directly recognizing a retention of the broader but shallower natural right, unquote. On the Republican side of that debate, Ginap observes that they were, quote, conceiving an important set of liberties as absolute barriers against government interference, as discrete privileges or immunities that stood in opposition to the very thrust of government power, unquote. Now, Campbell and Ginap argue that the Republicans' understanding of rights in particular was a departure from the understanding prevalent in 1789. But Ginap concedes that the Republicans, quote, claimed merely to be restoring the original fixed meaning of the First Amendment, unquote, and that the Anti-Federalists began laying the groundwork for the Republicans' view a decade earlier. Thus, to discount the rights as Trump's views that were clearly prevalent in 1798, one would have to believe that the conception of rights had changed radically in less than a decade, even though those advocating rights as Trump's in 1798 claimed to be faithful to the original meaning of the First Amendment, and even though some of them had played a role in enacting the First Amendment. While it's possible that Campbell and Ginap are right to discount the views manifested during the Sedition Act debates, it does seem more likely that the understanding of rights that was prominent in 1798 was also prominent in 1789. The repeated descriptions of the Bill of Rights as exceptions to government power throughout the late 1780s and into the 1790s are not easily reconciled with the rights revisionist argument that the Bill of Rights did not primarily operate as a trump on government action. Indeed, these are the kinds of statements that have led so many eminent legal historians, including Philip Hamburger and Michael McConnell, to argue that the rights codified by the Bill of Rights operated primarily as trumps. But we need not definitively resolve whether constitutional rights should be seen entirely as trumps to agree with Bruen's methodology. One need only conclude that the fixed legal content of the Second Amendment was likely to be expansive in scope, even if some aspects of the right were left to regulation. Given the fact that the broadly worded text of the amendment was chosen carefully to reflect the nature of the right, and given the historical support for a more aggressive rights as Trump's view, the more modest position that the Second Amendment, as well as other declaratory amendments, likely had an expansive fixed content, while also acknowledging some retained natural right space subject to regulation, has a strong basis in the founding era history. But even if one remains skeptical that constitutional rights like the Second Amendment were understood to have an expansive fixed legal content, there remains a strong argument in favor of the assumptions undergirding Bruen's methodology. And that's because, at worst, it is unclear whether Bruen is based on an ahistorical conception of rights. And in light of that ostensible unclarity, it makes little sense for the court to overthrow the understanding of rights on which, by the rights revisionist's own account, much of modern rights jurisprudence rests. Now, to be clear, this reason that I'm focusing on here for retaining Bruen's conception of rights is specific to the task of constitutional adjudication, rather than the task of intellectual history, in which Campbell and Gannap are primarily engaged. So it's no criticism of Campbell and Gannap that they have not addressed this point in advocating their historical arguments against Bruen. But insofar as one concedes that it is at least doubtful whether constitutional rights were understood to have significant fixed legal content at the founding, that should suffice as a matter of constitutional adjudication to retain the assumptions undergirding Bruen's methodology, especially at step 2. Once those assumptions are in place, step 2's methodology follows. Insofar as the Second Amendment declared a right that had a significant core of fixed legal content, Campbell's work confirms that the way to recover that content was by doing what Bruen does, examining the legal materials at the time of the text enactment. Those principles were found primarily in common law, but they could also be found in other legal sources. In Samuel Livermore's phrase, we look to, quote, the usages of law and practice, unquote, at the founding to recover the content of declared rights. As I noted earlier, this is exactly what the Federalists did during the debates over the Sedition Act. They examined the established common law meaning of the freedom of speech and of the press to recover its determinate limits. Bruen's step 2 therefore approaches the Second Amendment as the founders approached other declaratory texts, by looking to the law as it then stood, in Livermore's words, to recover the contours of the right. Bruen's methodology, therefore, is historically sound. It's grounded in the founding era conception of rights, and it is generally consistent with the rights revisionists' account of constitutional rights. Just as the rights revisionists are leading a revolution in how we understand rights to have been conceptualized at the founding, Bruen is leading a revolution in how we adjudicate rights in the present. Properly understood, these two revolutions need not be opposed to each other. The success of Bruen can, in large part, be the success of rights revisionism. Rather than set themselves against Bruen's methodology, the rights revisionists should work to reconcile Bruen's methodology with their understanding of rights, as I've attempted to do here. If they take up that challenge, I am confident that they will one day be able to join me, even in a qualified way, in affirming that Bruen was right. Thank you.
Thank you, Professor Alicea. So the floor is open for question. I see some students out there, and we always reserve the first questions for students. I see students from Constitutional Interpretation and Civil Liberties. Any of you have questions? Want to start us out? Don't all speak at once now. I even see an historian or two out there. Yeah, Ben Woodard.
So when we're looking to try to find this broader content, this step 2 of Bruen, and we're looking at practices in the founding era, or even perhaps expanding beyond just the immediate era around the founding, there's the concern with kind of the distinction you drew between just practices and how practices point us to a tradition. That there's a tradition that persists kind of regardless of what the practices are. I hosted Judge Mady on Tuesday, so we had a long conversation about this in particular, about the difference between tradition and practices. So drawing on that, that there is a concern that, perhaps there are some practices, there are some customs, there are some regulations that don't actually align with the principles expressed in the capital T tradition, in the underlying natural right. And kind of the question I talked about with Judge Mady, and the question I'm asking you is how do we disaggregate those? How do we understand, which are the practices and customs that actually point us to the correct understanding of the capital T tradition? Which ones are distractions from understanding that? How do we understand the actual contours of the right?
Yeah, that's a great question. It's a question that Bruen itself has to confront, right? In adjudicating the constitutionality of New York's law, in that case, Bruen has to sort through a lot of historical evidence to identify what are the governing principles here. That historical analysis is criticized by all sorts of legal scholars today about whether Bruen gave short shrift to some of the practices that might have supported New York's regulation in that case. But I guess stepping back, I would say that task that you're identifying, how do we sort through historical materials, various practices, to identify the relevant principles, and how do we identify aberrations or anomalies that we can set aside, is no different conceptually from what judges do every single day in looking at precedent. right? So when in our system, which is a precedent-based system, we look through, if you're a judge, you look through precedents to determine what are the governing legal principles that constitute our law today. And that requires identifying what statements in past opinions are aberrational, which ones are stray remarks, which ones are actually constitutive of the legal principles that are now our law, right? And lawyers and judges disagree about that all the time, right? There's no scientific process for determining what are the legal principles in prior precedents that really do constitute the law, and which ones are dicta, or which ones are just stray remarks, which ones have subsequently been abrogated by other holdings from the court. Those disagreements are just part of legal analysis under a system that emphasizes analogical reasoning, as ours does. So it seems to me that whatever challenges might be posed by what you just described, which is this principles, practices distinction, are no different in kind from the same problem that we face every single day in ordinary precedent-based adjudication. So to the extent that somebody says, well, that problem is fatal to the Bruen methodology, they would have to say that the same problem is fatal to precedent-based adjudication in general. Now, some people are willing to bite the bullet and say that, right? A lot of legal realists would say that. They would say, exactly, it's all arbitrary, it's all politics, all the way down. That's a much bigger jurisprudential debate. Bruen starts from the presumption of law being a real thing. It starts from formalist assumptions, not legal realist assumptions. And indeed, by adopting the founding era conception of rights, it even starts from natural rights, natural law assumptions, right? So both in its understanding of law and its understanding of rights, it's rejecting a kind of positivist and realist understanding that would be comfortable with the logical implications of saying that precedent-based reasoning is just as subject to the flaws of Bruen's methodology. So I think that once you bracket those larger jurisprudential debates, which I think we should if we're just going to evaluate Bruen on its own terms, it's really no worse off than our law is generally.
Terrific response, Joel. For people who haven't studied constitutional interpretation, Professor Alicea made reference to two schools of thought about law there, one formalism and the other legal realism. And just to make sure that people aren't lost, formalism is the basic idea that judges or other interpreters of laws, including constitutions, can actually be guided by legal provisions quite independently of their own prejudices or their own political beliefs or moral beliefs or religious beliefs. They can lay all that aside and be guided in their decision-making by the principles of law as set down by the legislature or the constitution maker. Legal realism is a school of thought that's extremely critical of that idea and believes that those formalities aren't actually what guide judicial reasoning or the reasoning of any legal interpreter. Rather, people will be shaped in their judgments fundamentally by other factors, their social backgrounds, their political beliefs, their religious beliefs, in the caricature version of it, what they had for breakfast. Okay, on to the next question. Floor is completely open for anybody who has a question. Yes, Zach Gardner.
Thank you so much, Professor Alicea. I had a question that's a little bit outside of the Second Amendment context and more in the unenumerated rights in general context in kind of American constitutional law. There's obviously the movement in understanding a general law background now to the American founding and the American framing, which incorporates, as you mentioned, certain principles from the common law, for example. And there's the whole debate about whether or not the common law and the natural law are as tightly wound together as maybe Blackstone would argue that they were. But one of my understanding of specifically the Ninth Amendment is that it's really a rule of construction that enumeration as it exists in Article 1 basically says enumeration limits the number of powers that you can have, for example, in Congress. But enumeration in this sense in the Bill of Rights doesn't do that. The Ninth Amendment basically says that enumeration works here in a different way than it works in other places. Could you see then, after that kind of long wind-up, could you see what do you see the court possibly doing then with further unenumerated rights that have been found in kind of the general Griswold sense of the penumbras and emanations? How do you see then maybe a Bruen approach being applied now to the rights that are argued to exist outside of the Bill of Rights that we maybe inherited from the common law, or then some kind of more activist sense and got from some general sense of kind of political right?
So I could take your question could be posing one of two issues. One could be, what would it mean to apply something like Bruen's methodology to what the court has recognized as unenumerated rights, like the right to contraception or things like that? That kind of methodology, a historical methodology, is very similar to the Glucksberg test that the court has already adopted and that it reaffirms in Dobbs in overruling Roe and Casey. Not to say that they're the same kind of test. They're not the same kind of test because the court in Bruen is purporting to conduct an originalist analysis, and it's deriving its methodology from the effort to get at the original meaning. Whereas Glucksberg, just frankly, right, was just kind of invented, right? It wasn't an attempt to get at the original meaning. Though I think it's worth noting that in Dobbs, the court does drop a footnote to say that if we were operating under the Privileges or Immunities Clause of Section 1 of the 14th Amendment and not through substantive due process, the analysis would remain largely the same, which seems to me to be an implicit assertion that the court was concluding that something like the Glucksberg test would be the way of identifying unenumerated rights under privileges or immunities through the 14th Amendment. But in any event, my point is to say that kind of move of using the general law and using historical grounding to identify unenumerated rights, aside from the Bill of Rights, just for example, in the 14th Amendment context, that's the move Glucksberg has already made in some respects. But the other question you might be asking is, what is the status of unenumerated rights under the 9th Amendment if you accept Bruen's premises, which seem to buy into the idea that there's all this content, all this legal content that is not in the text. And if you buy into that, what does that mean about the 9th Amendment? And there I would just point you to an article by Michael McConnell on the interpretation of the 9th Amendment. I think it's called Natural Rights in the 9th Amendment or something to that effect. What's remarkable about that article by Professor McConnell is that it agrees with so much of what the rights revisionists are arguing was true about the founding era conception of rights, except on this point about rights as trumps and the importance of enumeration. And there, Professor McConnell, and I fully agree with him on this, reads the evidence at the founding as establishing that not only do rights that are enumerated generally operate as trumps on government action, I just gave part of my remarks to support that view as well, but that the enumeration did have an effect of elevating certain rights, those that were enumerated, to the status of fundamental positive law, and those that were not enumerated do not have the status of fundamental positive law. Now that leads to the question: well, then what status do they have if the 9th Amendment is supposed to guard against denying or disparaging those other rights? Professor McConnell's argument, which seems correct to me, is that those rights retain the same status they had prior to the enumeration of other rights in the Bill of Rights. And what status did they have prior to enumeration? They were used as background principles, common law and other principles, for equitable interpretation of legislative enactments. So insofar as a legislative enactment seems to, if interpreted one way, be contrary to what was widely recognized as a natural right, even one not put into the Bill of Rights, perhaps judges would then be authorized to try to interpret that legislation not to abrogate or infringe on that natural right. But that's quite different than the status of those that were enumerated, which operate as trumps on government action, not just as ways of construing rights. But in that way, under Professor McConnell's view, you have not denied or disparaged unenumerated rights. They retain the same status they had prior to enumeration. It's just that prior to enumeration status was not as a trump on government action.
Joel, as Zach pointed out in the beginning of his question, the 9th Amendment on its face presents itself as a rule of construal. Would the simplest explanation simply be that the unenumerated rights are whatever you have in the absence of the enumerated powers? So no power, that means the right is retained against the national government, in which case you could have rights against the national government that are not rights actually against the states.
You could have rights against the national government, they're not rights against states because it's the inverse of the powers that they have.
Exactly right.
Yeah, I think that's entirely possible. Yeah.
Next question. Yes, sir, up here.
Hello. I appreciate the talk, and I generally agree with your analysis. But as I understand originalism, the one thing that I struggle with is change in technology over time. And looking at a number of rights, not just the Second Amendment, there is so much change in the advancement of technology. Things become cheaper, things become more powerful, more widespread, that if you look to the founding era, the founders would have no conception of any of these changes, and I think you're left with drawing analogies between then and now and trying to understand, but analogies are limited. So I'd like to understand your thought process as it relates to unanticipated changes in technology.
Sure. Well, Bruen itself acknowledges that, right? Bruen, in the process of explaining the importance of analogical reasoning, as you say, to its methodology, it acknowledges that the analogy might have to be looser when you're dealing with something that was completely unknown at the founding, right? It'll be harder to have as tight a nexus between the historical baseline and a current phenomenon if the current phenomenon has nothing that anticipates it at the founding, right? But to give you a more concrete kind of example, think of the historical tradition prohibiting arms in what Bruen calls sensitive places. So at the founding, there were laws that prohibited the possession of arms in certain locations, like courthouses, I believe legislatures as well, legislative houses. You could look at those laws and identify certain commonalities that those locations had and derive criteria that constitute the historical tradition. And then apply that to modern day things that didn't exist at the founding, like airplanes, right? We prohibit firearms on airplanes. Those didn't exist at the founding, but we're not at sea because we can look to what were the criteria for those places that exist at the founding that they thought were okay to exclude firearms from, and do those same criteria apply to airplanes? And it seems to me that the answer there is yes, because one of the things that those places at the founding had in common was that the government was stepping in to provide comprehensive protection for you within that limited space. So there was security, and there was no need for the right to self-defense because you were completely secure within this specific geographical area. The same is true for airplanes. Although, footnote here, the efficacy of the TSA. But anyway, at least ostensibly, that is supposed to be comprehensive security for you on an airplane, right? And that seems to me, therefore, to fall within the historical tradition, even though it was something that would have been inconceivable at the founding.
Good. Next question. Yes, down here.
This is probably going back to Heller, but could you kind of give us a recap on your view of the textual interpretation that minimize the importance of the mention of militias?
Right, that is going back to Heller. You're right. So in the 2008 case, District of Columbia versus Heller, the Supreme Court held that the Second Amendment protects an individual right to keep and bear arms for self-defense. Now, the text of the Second Amendment begins with what the court in Heller called a prefatory clause, which refers to the importance of a well-regulated militia being necessary to the security of a free state. Right? The right of the people to keep and bear arms shall not be infringed. Though that prefatory clause, the court, after an extensive historical analysis, concluded was not the operative language. That is to say, it's not the language that has the legal content. It is simply announcing the purpose of the Second Amendment. So the operative language is the right of the people to keep and bear arms shall not be infringed. And the question is, what did that mean? And could you derive an original understanding of that operative language that accorded with the prefatory clause? And that's the way Justice Scalia's opinion for the court in Heller proceeds. It goes through the original meaning of the operative clause and tries to derive to distill that down to answer the question of whether it's an individual right or not, and then asks, does this accord with what the prefatory clause seems to say? And says, yes, it does. It does seem to accord with it. And I think the key point here is it possible to have an individual right to keep and bear arms, and that right still supports the importance of a militia? Yes. Does the importance of a militia mean that there is no right to keep and bear arms individually for self-defense? No, that doesn't follow, right? The fact that the militia might have been a core purpose of the Second Amendment does not therefore mean that there is no individual right to keep and bear arms. And I would just point out, one of the most powerful textual points that the court makes, I think, in Heller, is that if you look at the right of the people, that kind of language, elsewhere in the Constitution, that never refers to a collective right. That refers to individual rights. Now, they might be individual rights that are exercised with some other people who are there as well, but ultimately, the law has always regarded those as individual rights. So it would be a very strange interpretation for the Second Amendment alone to use this language and refer to some sort of collective right that was not held individually. That's one of Justice Scalia's more persuasive arguments there.
Next question. Yes, back to Ben Woodard. Ben?
So to follow up on my earlier question.
Okay.
You gave a very nice pragmatic answer, but to get more into the theory side of it. Yes, I would fully agree that judges in a precedent-based system have to be looking at examples from the past, see what is a focal case of this tradition, what is outside of the focal case, what is but if we're expanding that source pool to include elements of natural law and natural rights, is it not simpler, easier, more judicially effective, and just all around better to, instead of being, oh, I'm counting framers, I have 5 framers, you have 8 framers, I have 9 Federalist Papers, you have 2 Federalist Papers. Is it not better to consider, if we're talking about natural law and natural rights, to engage kind of in the mode of critical morality and moral reasoning today and say, what actually makes sense as an interpretation of this moral principle, as understood and informed through history and how it was put in the text, not completely abstracted from the text, but saying what we're doing today is instead actually trying to figure out what makes sense as a principle morally, not just you have 9 framers, I have 5 framers kind of historical balancing.
So depending on what you meant by that, I either emphatically disagree or strongly agree. It really depends. If what you meant was because these rights are emerging out of a moral tradition and a legal tradition and are supposed to be coherent in some sense, judges should adopt themselves, they should take on the normative premises of the founding era, if 1791 is the right ratification year, 1868 if that's the right ratification year. They should take on the normative assumptions of the ratifiers, and in distinguishing between practices and principles, ask, does this practice seem normatively salient in light of what this right was, considered from the normative perspective of those at the time? If that's what you mean, I agree. In fact, have argued exactly for that approach in Bruen was right. My article in Bruen was right. I think that is the key to distinguishing between what I call substantive and incidental features of the right. So we could see some practices are, this statute was decided on a Tuesday. Well, that's an incidental feature, right? That obviously has no relationship to the substance of the right. And so the fact that it was decided on a Tuesday should not be baked into how we're thinking about the right. But there's some elements of historical practices that are clearly substantive, that do make sense in light of the normative framework for understanding the right. But notice here that what I was just articulating, and attributing in some way to you, is a mixed historical and normative analysis. it's historical in that you're going to have to look up and figure out historically what were these normative assumptions and theoretical premises. You then have to take those on and through those lenses try to figure out whether some practices would be substantive or incidental, right? Now, insofar as instead what you meant, and there were some things you said that could suggest this, was that judges should simply engage in moral reasoning on their own, apart from the historical premises, apart from that kind of historical analysis I was just saying. That is fundamentally contrary to the original understanding of the judicial role under Article 3 of the Constitution. And here, Judge Campbell and I would be completely in agreement because central to the understanding of rights at the founding was, as I said, that we enter into government but retain control over our rights. How? Through representative institutions. And that means that the regulation of those rights, the determination and specification of their contours, their regulation for the common good, none of that can be done by the judges who are unelected and are not a representative institution, but through our legislatures or through our customs and practices that manifest themselves and then become recognized through the common law, which is not judge-made law in their conception of rights, of judicial power, right? But the idea, which is now just so endemic to American constitutional law, that it is judges who should be determining whether this is a compelling state interest, whether these means of achieving that interest are good or not, or proportionate or not, and using their kind of unconstrained moral reasoning to evaluate those things. The idea that that would accord with the original understanding of judicial role has no basis in the founding era history.
I want to say I would put myself, I think, in the former camp with you. But I appreciate that you disaggregated the two and responded to both, because I think the second, there is kind of an underlying temptation and argument there in a lot of conversations about philosophy of law today. And so I think it's important, to disaggregate both of those and respond to them. So I appreciate your answer.
As Judge Bork said, the tempting of America.
Yes.
Well, it's interesting, Joel, because when you were studying constitutional interpretation here, the view that you've emphatically rejected was almost entirely associated with the political left.
Right.
Today, there, of course, still strong representation for the view on the left, but it now has significant support on the right.
That's right.
So you're sort of standing up against both sides of the political spectrum to some extent.
That's true. And in some of my other work, justifying originalism from a natural law perspective, I was put in exactly in that situation of having most of my opponents be on the political right in arguing for that. It's a very uncomfortable position.
It's an absolutely remarkable, development just in our own lifetimes. Other questions? Yeah, you have a second. Go right ahead. Yes, sir.
I know everyone hates prediction questions, but do you predict that there will be any additional constitutional amendments in your lifetime? And if not, is that a concern to you?
That's interesting. Well, I like to think of myself as still relatively young, so I would think that there's still plenty of time for constitutional amendment. And there are some ideas for amendments that seem to have broad support if you look at polls. So, for example, we just had this for really the first time in living memory, this situation where you had a president who the American people perceived to be severely impaired cognitively. Whether you think that's true or not is a separate question. The question is that there seems to be a perception that he was impaired towards the end of his term. And I think that does raise a real question about, as we have people living longer, should we impose some sort of age limit on candidates for federal office or for judges, potentially, some sort of mandatory retirement age? I think that question, while it was very much bound up with partisan considerations in the last election, is a real question moving forward as people are living longer. And it just wasn't as big of a question 20 or 30 years ago. And so I think that is one area where I could see a potential consensus in the future for mandatory retirement ages or age cutoffs for running for office. But I don't know.
Sometimes the place to look is to state constitutions, where you have provisions that are very, very common in state constitutions, but we don't have in our national constitution. I think the best example here is a constitutional requirement of a balanced budget. So I think it's conceivable, if not in my lifetime, in Professor Alicea's lifetime, that you could have substantial support for a balanced budget constitutional amendment. Other questions or comments or points? Adam, I can't tell if that's a hand up or you're just, no, okay. Any others? Well, if not, we will conclude. Joelle, the other day, and you know, people don't like to be asked to predict things, but you are occasionally, and I was asked by a Washington Post reporter to predict who would be the next pope. So I said, Melinda Hanover, Melinda, I've got a heart-head conflict. Remember Thomas Jefferson's heart-head? I had a different version of the heart-head conflict. I said, my head tells me it's going to be Cardinal Pizzaballa, the Latin patriarch of Jerusalem. But my heart tells me Fridolin Ambongo of the Congo. So I was torn. But if a reporter asks me, as I expect one will do soon, who will be your first student to go on to the Supreme Court of the United States? I will have no heart-head conflict. Both will say, Joelle Alicea. Thank you for being with us, Joelle.